It would be impossible to imagine two cases in which the decisions were in more flagrant contradiction than in those of Franklin versus Neal and Thompson versus Dominy, decided by the very same judges within a few months of each other. The ship owner and the pawnbroker were exactly in the same position. They were the mere bailies of the goods and not the proprietors. Pawnbrokers' tickets and bills of lading are instruments of exactly the same nature. They are both documents of title and not choses in action. The court allowed that in each case, the property in the goods passed directly from the original owner to the transferee. In Franklin versus Neat, the court held that the transferee had the same rights as the original owner and might sue the pawnbroker, though he had not undertaken to deliver the watch to any transferee. In Thompson versus Dominy, the same court held that the endorsee had exactly the same right as the original owner, but could not sue the bailee for his own goods, which the bailee had expressly undertaken to deliver to the endorsee. In the one case, the court held that the legal owner might sue. In the other case, the same court held that the legal owner could not sue. The dogma of the court, which by their own showing was erroneous, being thus in hopeless conflict with the interests of the mercantile community. It had to be remedied by Act of Parliament, as in the former case of promissory notes. This was done by the Bills of Lading Amendment Act, Statute 1858, Chapter 4, or Column 4, C4. The dogma of the modern judges that choses in action are not transferable applied, of course, to policies of insurance. And to remedy this, the Policies of Insurance Act, 1867, was passed to permit assignees of policies of insurance to sue in their own names. Mr. Bunyan remarks that this act may be esteemed a first step to making choses in action assignable at law. The last step came much sooner, perhaps, than Mr. Bunyan expected. Appointment of a royal commission to prepare a digest of the law of England. 30. In 1867, the government appointed a royal commission to prepare a digest of the law of England in anticipation of the contemplated fusion of law and equity, which was subsequently enacted by the Supreme Court of Judicature Act of 1873, which came into operation on the 1st of November, 1875. Among the commissioners were Lord Chancellor Cranworth, Lord Westbury, Lord Carnes, Lord Hatherley, Lord Selborne, and Lord Penzance, to mention only those of judicial rank. The commissioners determined to prepare a digest of 3 branches of the law, as specimens of a digest of the whole law. They invited members of the bar to offer themselves to prepare the specimen digest under their superintendence. One of the branches selected was bills of exchange, banknotes, etc. This digest was not to be a mere register of decisions. It was expressly intended to be a declaration of the law on all points, and consequently it necessarily involved the strict investigation and final settlement of all disputed points, contradictory doctrines, and conflicting cases, as well as the exclusion of all erroneous cases. In the early editions of my Theory and Practice of Banking, I had stated the law regarding the transfer of choses in action, in accordance with the doctrines then held by all the judges and laid down in all textbooks of mercantile law, as I naturally presumed that the judges knew their own law. Upon entering this competition, I began to reflect that the current doctrines regarding the transfer of choses in action were contradictory. While it was strenuously maintained that choses in action were absolutely inalienable at common law, so as to enable the transferee to sue the debtor in his own name, it was perfectly acknowledged that in some cases it was quite legal to transfer a debt and that the transferee might sue the original debtor. It was perfectly acknowledged that if the creditor, the debtor, and the transferee met together, the creditor might, with the debtor's consent, transfer his right of action to the transferee. The debtor might then agree to pay the transferee instead of his primary creditor. When this was done, a valid contract was created between the debtor and the transferee, which canceled and extinguished the two preceding contracts, that between the debtor and his creditor, and that between the creditor and the transferee. And the transferee might then sue the debtor because there was now a privity of contract between them. This was what, as has been shown in the preceding section, is termed a novation. And this form of novation was perfectly acknowledged in a whole series of cases to be perfectly valid. But though it was admitted that a debt might be sold and alienated orally to a specific individual to whom the debtor personally entered into a contract, it was strenuously maintained that it was contrary to law to issue a written obligation payable to order or to bearer, or to any unspecified and indefinite assignee. And it was alleged that no contract could be created between the original debtor or obligor and such infinite bearer or assignee giving the latter an action against the debtor. This, of course, involved the general question: what is the common law of England respecting the transfer of obligations, oral and written? Or what is the common law of England with respect to the transfer of written obligations, which the obligor himself had created transferable? As the very purpose of the digest was to declare the law on this point, it became necessary to trace the doctrine through the whole series of reports to their earliest sources. The result I arrived at is contained in the preceding paragraphs and need not be repeated here. I proved by a series of cases beginning about 1250 and ending in 1800, a period of 550 years, that the dogma held by modern judges that choses in action were inalienable at common law, with the sole exception of bills of exchange, had no foundation whatever in fact, and that it was entirely due to the narrow dogmatism of Lord Kenyon, and that it had no earlier date than 1800. Having laid these investigations before the commissioners, whose chairman was Lord Cranworth, who had enunciated the doctrine that it was not to be tolerated by the law either of Scotland or England that any person should issue floating rights of action against himself, I was unanimously selected to prepare the digest of the law of bills of action, etc. My selection by the commissioners was, in effect, equivalent to a judgment of the House of Lords in my favor, because the commissioners included all the lords except one. And if they approved of my written arguments in their capacity as commissioners, they must have done the same if I had had the opportunity of addressing them in their capacity of law lords. I was invested with the duty of reducing into systematic and scientific order the whole mass of cases on the subject, both at law and in equity. I was instructed not to pay any regard to any decision of any court or judge, nor to be textbook, but that it was my duty to declare the law on every point in the subject. This therefore involved the duty of examining and approving, confirming, modifying, or reversing the decisions of all the courts of law and equity on this subject. I stated the rules of the common law relating to the transfer of choses in action in these words. At common law, a creditor cannot transfer his debt or right of action to a third person without the consent of the debtor, so as to enable the transferee to sue the debtor in his own name. But wherever the debtor assents to the transfer of the debt either orally or in writing, the assignment of it by the creditor is irrevocable, and the transferee may sue the debtor in his own name. I set aside the whole of Lord Holt's decisions relating to promissory notes, which had been accepted as law for 160 years, with one exception, as erroneous, and appended this note. The legality of promissory notes is sometimes supposed to rest solely upon the statute of Anne, but there can be no doubt whatever that the series of decisions which were the cause of the act being passed are erroneous, and that the act was superfluous. In 1870, the commissioners discontinued the work of digest, and consequently, my digest was never published under their authority. But I introduced these doctrines as having the private approval of the commissioners into my Principles of Economical Philosophy, published in 1872. The case of Crouch versus Credit Fontier of England, 31. This work had only been published a very short time when a very awkward incident occurred. The creditor Fontier of England issued an obligation which they termed a debenture, by which they promised to pay the bearer the sum of £100 on the 1st of May, 1872, or upon any earlier day upon which the bond should be entitled to be paid off, or redeemed according to certain conditions printed on it. The bond further promised to bear interest at 8%, payable half yearly on the 1st of November and the 1st of May in each year, from the 1st of November 1869 to the 1st of May 1872, unless it should be drawn for payment before the 1st of May 1872, in which case interest was to cease from the day it was drawn. One Mackin bought 10 of these debentures. In July 1869, his house was broken into and they were stolen. The bond in question was drawn for payment on the 1st of November, 1870. Mackin, having received substituted bonds, Mackin, having received substituted bonds on giving notice of his loss to the company and an indemnity, received payment of the debenture. At the end of 1871, the plaintiff bought the debenture from a person who afterwards disappeared and sued the company for payment of it. It was not disputed that he gave value for the bond without notice, and at the trial before Bramwell, B, he gained the verdict. The questions before the court and bank were, number 1, whether the debenture was a negotiable instrument. Number 2, whether, if it were so, it was not overdue, and so had lost its attribute of currency or negotiability. The judgment of the Court of Queen's Bench was delivered by Blackburn, J, in the absence of the Chief Justice. He began by allowing that such instruments had been for some time treated as negotiable. He then said, the general rule is not disputed that a chosen action cannot be transferred at law at all. The first question, therefore, is whether this instrument is a promissory note. It is under seal and therefore is prima facie, a covenant and not a promise. And it is quite clear that a covenant to pay money is not negotiable by the custom of merchants. There is no case in the books where a bill of exchange made under seal has been sued upon. The negotiability of promissory notes depends, in part at least, upon the statute 3 and 4 Ann, Chapter 9 or Column 9, and it seems to have been the opinion of Lord Justice Wood in regarding General Estates Company and of Malins, V.C. in regarding Imperial, or in reference to Imperial Land Company of Marseille, that in as much as that act enacts that promissory notes in writing, it follows that a corporation fixing its seal to a written promise to pay must be considered as signing the promise, not as covenanting under seal to fulfill it. And so that statute says, by implication, that what would at common law be their covenant to pay is their promise to pay. But although it intimating their opinion, neither of the learned persons referred to gave any decision on the point, as it was not necessary for the purpose of the cases before them. Neither is it necessary for us to decide the point, as for reasons which will presently be given. The instrument in question, even if underhand, could not be a promissory note. But we wish to point out that in Glynn versus Baker, the form of the East India bond was that the East India Company acknowledged to have received of W.G. Sibley £100, which the company promised to pay to Sibley, his executors or assigns by endorsement. It was therefore in form a promissory note for value received payable to order, and it had been signed as such by an agent of the East India Company, would have been negotiable. But it was a bond under seal of the East India Company, and LeBlanc J. says, it is clear that no action could have been brought on this bond, but by Sibley, the obligee, or in his name, or if he died in the name of his executors. The alarm occasioned by this decision was so great that within a month afterwards, an Act 51 Geo the third, Chapter 64, Column 64, was passed to make East India bonds negotiable like promissory notes. It seems not to have occurred to anyone that it could be said that this was already done by virtue of the Statute of Anne, the promise in writing being signed by the East India's Company seal. This seems a strong authority for saying that instruments under the seal of a body corporate are not exceptions from a general rule laid down in bills on bills that, at common law, bills of exchange and promissory notes, being simple contracts, cannot be under seal, at least, so as to retain their negotiable qualities. But it is not necessary to decide in the present case whether an instrument under the seal of a corporation can be a promissory note. For the contract of the credit foncier is not merely to pay the money, but also to cause a portion of the bonds to be drawn in the stipulated manner, and anyone entitled to sue on the contract contained in the instrument would be entitled to sue for damages if the company did not fairly give him his chance of having his bond drawn according to the stipulated conditions. And it is obvious that such a contract as that cannot be a promissory note. He is also obligated to contend that they could give a right of action in his own name to any holder, though the general rule would give no such right of action to the holders. There is no decision or authority that it is competent to a party to create by his own act a transferable right of action on a contract. It is enough to refer to Dixon versus Beauville and Thompson versus Dominy as authorities, that he cannot, irrespective of custom, so create it. We have already intimated an opinion that it is beyond the competency of the parties to a contract to confer on the assignee of that contract a right to sue in his own name. The court then made the rule absolute to enter the verdict for the defendants, but gave the right to appeal. No appeal, however, was made. And if it had not been for a subsequent case, this case might have done boundless mischief in perpetuating error. It will be seen by referring to the preceding section that every one of the statements in this decision, both of law and fact, are perfectly erroneous and are in direct contradiction to the principles which I had established in my digest with the approval of the Law Digest Commissioners. On the case of Goodwin versus Robarts, 32. At length, this great quarrel was brought to a final settlement and determination in the case of Goodwin versus Robarts, LR 10 Exchequer Exchange, page 337. Beyond all comparison, the most important mercantile case in modern times, or indeed of any time. The Russian government, being about to raise a loan on bonds, appointed Messrs. Rothschild, their agents, Messrs. Rothschilds and their agents. Messrs. Rothschilds issued scrip for these 100-pound bonds as a receipt for 20 pounds paid on account of the bonds, and as payment of the successive installments at the times specified, the bearer was to receive the definite bonds. In February 1874, the plaintiffs purchased 200 pounds of the Russian scrip, on which the installments were fully paid up in advance, and left it in the hands of his broker, who, improperly and contrary to good faith, pledged it with the defendants as security for a loan. The broker became bankrupt, and the defendant sold the scrip in the usual way of business, and in ignorance of the plaintiff's title. It was proved that such scrip for loans to foreign governments, entitling the bearers thereof to bonds, had been well known to and largely dealt in by bankers, money dealers, and members of the stock exchanges, English and foreign, for above 50 years. And such persons had, during that period, bought and sold such scrip and lent money to it, and dealt with it in every way as a negotiable instrument, transferable by delivery. The question was whether such strip was in point of law negotiable, so that the defendants, the innocent holders for value, might retain the proceeds from the true owners of it. This case, it will be observed, extended the question of negotiable instruments, because all instruments hitherto found to be negotiable had been actual obligations to pay money. But this was only a promise to deliver an obligation to pay money. The Court of Exchequer unhesitantly gave judgment for the defendants. The case was then taken by appeal to the Court of Exchequer Chamber, and the unanimous judgment of the court was given by Lord Chief Justice Cockburn on the last day of its existence, July 7, 1875. In the course of the argument before the court, Lord Holt's cases, so often alluded to, and which I had set aside in my digest, had been cited, and the Lord Chief Justice spoke of them in terms of the strongest condemnation, and said that they were a blot upon their judicial history. The Lord Chief Justice, having reviewed all the arguments against the negotiability of the script, especially the doctrines expressed in the preceding case of Crouch versus the Credit Fontier of England, that it is not competent for anyone to create floating rights of action against himself, and having given the fullest consideration to this argument, we are of opinion that it cannot prevail. It is founded on the view that the law merchant thus referred to is fixed and stereotyped, and is incapable of being expanded and enlarged so as to meet the wants and requirements of trade in the varying circumstances of commerce. It is true that the law merchant is sometimes spoken of as a fixed body of law forming part of the common law, and as it were, coeval with it. But as a matter of legal history, this view is altogether incorrect. The Lord Chief Justice then proceeded to speak of bills of exchange and of promissory notes, and said that the common notion that promissory notes were not used in England till the end of the 17th century was a mistake. Mr. MacLeod shows that promissory notes payable to bearer or to a man and his assigns were known in the time of Edward IV. After referring to several of the cases before recited, he said, thus far, the practice of merchants, traders, and others of treating promissory notes, whether payable to order or to bearer, on the same footing as bills of exchange, had received the sanction of the courts. But Holt, having become Chief Justice, a somewhat unseemly conflict arose between him and the merchants as to the negotiability of promissory notes, whether payable to order or to bearer. The Chief Justice taking what must now be admitted to have been a narrow-minded view of the matter, setting his face strongly against the negotiability of these instruments, contrary, as we are told by authority, to the opinion of Westminster Hall, and in a series of successive cases persisting in holding them not to be negotiable by endorsement or delivery. The inconvenience of trade arising therefrom led to the passing of the statute of 3 and 4 and, chapter or column 9, whereby promissory notes were made capable of being assigned by endorsement or made payable to bearer, and such assignment was thus rendered valid, beyond dispute or difficulty. It is obvious from the preamble of the statute, which recites that it had been held that such notes were not within the custom of merchants, that these decisions were not acceptable to the profession or to the country. Nor can there be much doubt that by the usage prevalent among merchants, these notes had been treated as securities negotiable by the customary method of assignment. As much as bills of exchange, properly so called, the Statute of Anne may indeed, practically speaking, be looked upon as declaratory statute, confirming the decisions prior to the time of Lord Holt. The Lord Chief Justice then, having reviewed several other cases, came to the case of Crouch versus the Credit Fontier of England in his own court, but decided in his absence. He expressed disapproval of the reasons given for the judgments, that it was not competent for the company to make instruments negotiable which were not negotiable at at common law, though he said the judgment might be supported on the ground that the usage was not proved to be general. We cannot concur in thinking that if proof of general usage had been established, it would have been a sufficient ground for refusing to give effect to it, that it did not form part of what is called the ancient law merchant. If we could see our way to the conclusion that in holding the script in question to pass by delivery or to be available to bearer, we are giving effect to the usage incompatible either with the common law or with the law merchant, as incorporated into and embodied in it. Our decision would be a very different one from that which we are about to pronounce. But so far from this being the case, we are, on the contrary, in our opinion, only acting on the established principle of that law in giving legal effect to the usage now become universal. To treat this form of security being, on the face of it, expressly made transferable to bearer, as to the representative of money, and as such being made to bearer as assignable by delivery. The court then affirmed the judgment of the Court of Exchequer, and thus all the courts of common law held that the script was a negotiable instrument. This judgment was afterwards affirmed by the House of Lords. The Lord Chief Justice had the paper 1 prepared for the Law Digest competition before him, and in the course of the judgment, he did me the very high honor to refer to it as follows. We find it stated in a law tract by Mr. MacLeod entitled Specimen of a Digest of the Law of Bills of Exchange, printed, we believe, as a report to the government, but which, from its research and ability, deserves to be produced in a form calculated to ensure a wider circulation, etc. I had already published the results arrived at in my Principles of Economical Philosophy in 1872. This judgment confirmed them in every particular, and they are repeated in my Theory and Practice of Banking. And in this work, so that I have done whatever has been in my power to fulfill the suggestion of the Lord Chief Justice, chose an action made transferable by statute without the consent of the debtor. 33. The courts of law never adopted the bold suggestion of Ashurst and Buller that they should drop the formality of requiring the transferee of a debt to sue in the name of the transferor. But this has at length been done by the Supreme Court of Judicature Act 1873. By Section 25, Section 6 of that act, it is enacted. Any absolute assignment by writing under the hand of the assignor, not purporting to be by way of charge only, of any debt or other legal chose in action, of which express notice in writing shall have been given to the debtor, trustee, or other person from whom the assigner would have been entitled to receive or claim such debt or chose an action shall be, and be deemed to have been effectual in law, subject to all equities which would have been entitled to priority over the right of the assignee, if this act had not passed, to pass and transfer the legal right to such debt or chosen action from the date of such notice, and all legal and other remedies for the same, and the power to give a good discharge for the same without the consent of the assignor, provided always that if the debtor, trustee, or other person liable in respect to such debt or chose in action shall have had notice that such assignment is disputed by the assignor or anyone claiming under him, or if any other opposing or conflicting claims to such debt or chosen action, he shall be entitled, if he think fit, to call upon the several persons making claim thereto to interplead concerning the same, or he may, if he think fit, pay the same into the High Court of Justice under and in conformity with the provisions of the acts for the relief of trustees. It will be seen that this clause confers the right upon creditors to transfer their debts or chooses an action without the consent of the debtor, and consequently, if the holder of such obligation not made transferable by the express will of the obligor, gives notice to the debtor in terms of this clause, he can maintain an action on it. But it still leaves untouched the case of an obligation created transferable with the express consent of the obligor, which is transferred without a written notice to the obligor, and in such cases, which form the vast majority, the rules of the common law still apply. If there should be any doubt on such cases, which we have established, there never was. It is provided for in section 11 of the same section, which says, generally in all matters not herein before particularly mentioned, in which there is any conflict or variance between the rules of equity and the rules of the common law with reference to the same matter, the rules of equity shall prevail. Thus, the mercantile law of England is now assimilated to that of Europe. Section 3, on the extinction of obligations, on the limits of credit. 34. We have now to consider the various methods by which obligations are extinguished. Credit being the right to demand some person to pay or do something, and debt being the duty of some person to pay or do something. Of course, when the debtor has paid or done the thing he is bound to do, he has fulfilled and discharged his duty, and therefore the right of the creditor is satisfied and extinguished, and thus the obligation is annihilated and extinguished. It has been shown over and over again that credit is the name of a species of property, commodity, or merchandise of the same nature as, but inferior in degree to, money, that it fulfills exactly the same function as money as a medium of exchange and circulation. It is a property, commodity, or merchandise cumulative to money, and is in all its effects on prices and productions exactly equivalent to an equal sum of money. Credit is, in fact, to money what steam is to water. Credit is to money what steam is to water, and like that power, while its use within proper limits is one of the most beneficial inventions ever devised by the ingenuity of man, its misuse by unskillful and unscrupulous persons has produced the most fearful calamities. Credit, like steam, has its limits, and we have now to investigate the proper limits of credit and to explain the various methods by which it is extinguished. Credit, no doubt, is of the same nature as money, being the right or title to a future payment. But there is this difference between them, that there is no time limited in which the holder of money shall demand a satisfaction for it, nor is it limited to any particular satisfaction. He may keep it as long as he pleases himself, or he may transmit it to his descendants, and they may exchange it for a satisfaction at any time they please. But credit is always created with the express intention of being, or of being capable of being, extinguished at a certain short definite time. It is unextinguished credit which produces these terrible monetary cataclysms which scatter ruin and misery among nations. It is chiefly by the creation of excessive credit that overproduction is brought about, which causes those catastrophes called commercial crises, and it is the inability of credit shops to extinguish the credit they have created, commonly called the failure of banks, which is the cause of the most frightful social calamities of modern times. The true limits of credit may be seen by the etymology of the word, because all credit is the promise to pay or do something in the future. And that something, whatever it is the value of the promise or credit. That something need not necessarily be money. It may be anything else. It may be any other chattel, or it may be a promise to do something. The credits, however, which are the subject of this work, are always promises to pay money, and it is just on this point that literary economists are utterly at fault, because a bill or note is an obligation to pay money. Many uninformed writers suppose that they must always be paid in money or bank notes, and therefore that the issues of credit have always a fixed relation to the quantity of money in a country, or in mathematical language, are a definite function of it. Thus, Colonel Torrens, who was of the influential sect who procured the enactment of the Bank Charter Act of 1844, says, a bill of exchange may also pass from purchasers to vendors many times a day, but no one of the successive transactions of which it is the medium can be fully closed until the last recipient has received in coin or banknote notes the amount it represents. Now, no doubt 300 years ago, as far as we are aware, it is true that bills were paid in money, but that has long ceased to be the case. At the present day, probably not one bill in 10,000 is ever paid in money or banknotes, but by other methods which were but by other methods which we have now to describe. Thus, those who imagine that bills and notes at the present day are always paid in money have as much idea of the present organization of the system of credit as those who know nothing of the steam engine beyond the first rude attempts of Watt have of the last new triple expansion engines of the Aurora or the Umbria, or as those who know nothing of the locomotive beyond George Stephenson's rocket have of the last new locomotive on the London and North Western Railway. The only real difficulty in the case, as has been frequently observed, is for lay readers and writers to understand that a right of action or promise to pay is itself independent exchangeable property, merchandise, or a chattel, quite distinct from the money promised itself, and that it circulates in commerce by itself exactly like money. But of course, the value of the promise or right of action is the thing itself. And subsequently, if the thing itself is not forthcoming, the right of action has lost its value. This consideration at once shows the limit of credit. Assuming the credit to be what is its best known form in this country, the right to demand money, it is quite clear that as long as a person has in his possession sufficient money, or what is held to be equivalent to money, to discharge his debt when it becomes due, the credit has not been excessive. In this section, we shall consider only solid credit, by which we mean credit which is redeemed at maturity, reserving the abuses of excessive credit and its consequences and remedies to a future chapter. The futile nature of the speculations of lay writers on this subject consists in the fact that by the highly organized system of modern credit, it is only an infinitesimal portion of bills that are ever paid in money at all, but they are paid in the equivalents to money. The institution of banks and bankers who create currency by means of their credit, either in the form of notes or deposits, has enlarged the limits of credit, at least 1,000-fold, but yet the principle of the limit remains the same. Credit always has to be redeemed, and if this can be done, the credit has been sound. And if this can be done, the credit has been sound. Hence, credit is never excessive, whatever its absolute amount may be, as long as it always returns to itself. On the extinction of obligations, 35. We have now to consider the various methods by which obligations are extinguished. Credit being the right to demand something to be paid or done, and the debt being the duty to pay or do that something. The payment or the performance of the thing promised fulfills, discharges, and extinguishes the duty, as well as the right, and thus the obligation is absolutely annihilated and extinguished. Commercial credit in this country is always expressed to be payable in money, and it is often supposed that bills of exchange are always paid in money or banknotes. But as has been shown in the preceding paragraph, that it is a vital error. There are other methods besides payment in money by which obligations are extinguished. And in this country, the amount of bills which are paid in money is infinitesimal compared to those which are paid in other ways. There are four different methods by which obligations may be extinguished. These are, number one, by acceptation or release, by payment in money, by novation, renewal or transfer, by compensation or set-off. On acceptation or release, 36. We have already described how the obligatio verbis or litores, or the oral or written obligations were created. When the debtor came to repay the loans, the proceedings were reversed. He brought the money to his creditor and said something of this sort to him. Have you received what I promised you? I have, and have entered it as received. In this case, the debtor made an entry of money paid in his ledger, termed expensilatio, and the creditor made a correlative entry of money received in his ledger, termed acceptilatio. These entries of expensilatio and acceptilatio, when once formally made in their respective ledgers of the parties, were final and conclusive, and could not be questioned. All contracts or obligations created by the mutual consent of parties may be extinguished, canceled, dissolved, or annihilated by the same mutual consent of the parties by which they were created. Consequently, if for any reason whatever the creditor chose to release the debtor from his debt without the actual payment of money, it was done by the solemn form of acceptilatio. The debtor went through the legal form of question, and the creditor went through the legal form of answer, and then made the formal entry of acceptilatio in his ledger. It was then a valid and final release, and it could not be questioned or disputed. So at present, if a creditor gives a debtor a formal written receipt for money due, it is a valid and final release of the debt. We shall hereafter give some examples of acceptation, which may surprise some of our readers. For acceptation, see Gaius III, page 169 to 175, Institute Justine, volume 3, 29,1, Theophilus, volume 3, page 29, digest, XLV1 or VI 4, Basilica XXVI, 9. The release of a debt is in all cases equivalent to a gift or payment in money, 37. Euler, as we have seen above, says that if a person has nothing and he owes 50 crowns, his property is 50 crowns less than nothing. His property is minus 50 crowns in parentheses, i.e., he is under the duty to pay 50 crowns and has nothing to pay them with. He then says that if any person made the debtor a present of 50 crowns to pay his debt with, he would be 50 crowns richer than he was before, though his property would then be zero. Euler is right so far as he goes, but he has only stated one side of the case, because the same result may be attained in another way. As the same result follows, whoever gives him the 50 crowns, we may suppose his creditor makes him a gift of 50 crowns. The debtor then may give his creditor back his 50 crowns, and he so discharges his debt. The debtor is now 50 crowns richer than he was before, and his property is now zero. Now, if money be positive, the gift of money is also positive, and therefore the gift of money is positive times positive, which equals positive. But there is another combination of signs which gives positive, and that is minus times minus. And there is another way of arriving at this result. Suppose that instead of the double operation of the creditor giving his debtor 50 crowns and receiving them back in discharge of his debt, he simply releases the debtor from the debt. Then the debtor would be 50 crowns richer than before, and his property would be zero. Now, a debt is minus, and taking away or releasing is also minus. Hence, releasing a debt is minus times minus. Hence, releasing a debt is absolutely equivalent to making a gift of money. That is minus times minus equals plus minus. That is minus times minus equals plus multiplied by plus in economics, as it does in every other branch of science. This example shows that the release of a debt is, in all cases whatever, equivalent to the gift or payment of money, a principle of immense importance in commerce, and the application of which may surprise some readers. So the digest 1, 17, 115 says, he who is released from an obligation has gained. So the digest 1, 17, 150, an insolvent debtor being freed by a release has gained the full amount of what he is released from. So Pothier say, a release is a donation. Or Tolane says, the release from a debt is always classed as a donation in Roman law. So von Savigny states, a simple contract or the release of a debt may be the subject of a donation. Also, the increase of wealth may result from ... a credit given to the debtor or the release of a debt. Every release of a debt enriches the debtor. The amount of the donation is always equal to that of the debt, even though the debtor is insolvent. Although the release from a debt destined never to be paid seems a thing of no consequence, the increase of property does not the less exist. In effect, not only does property represent a quantity always indeterminate, but its total value may also be either positive or negative. Negative property is the inverse of a right, a debt or duty. If then property is reduced to a negative value, the diminution of minus is in law a change identical with the increase of plus for a positive value. The release of a debt always constitutes a gift equal to the amount of the debt, even though the debtor is insolvent. So the release of a debt to a debtor may be a legacy. Application of the principles of algebra and mercantile law in commerce. 38. It has now to be shown how the algebraic doctrine that minus times minus equals plus times plus and its legal equivalent, the release of a debt, is in all cases equivalent to a payment in money. We are applied in commerce. Suppose that I owe 100 pounds to a banker. In how many ways can I pay him? Number one, I may pay him 100 pounds in actual money. That is plus times plus. Number two, if I happen to possess 100 pounds in his notes, I may tender him his own notes. Or if I have an account with him, I may give him a check on my account. That is, in either case, I release him from his debt to me. That is minus times minus. That is, releasing the banker from his debt to me is paying my debt to him. Number three, I may pay him 50 pounds in money and 50 pounds in his own notes or by checks on my account. Paying him in money is plus times plus. Paying him in money is plus times plus. Tendering him his own notes or giving him a check on my account is minus times minus. And the combined effect of the two is to discharge and extinguish my debt of 100 pounds. Thus, I may pay a debt to my banker entirely in money, entirely in his own notes and by check, or partly in money and partly by notes or checks. And the effect of these several modes of payment is absolutely identical. Thus, it is seen that the doctrine that taking away a negative quantity is absolutely equivalent to adding a positive quantity is universally true in all branches of science. That is, in all sciences whatever. Negative times negative equals plus times plus, and in mercantile algebra, it is to be thus interpreted. The release of a debt is, in all cases, equivalent to a payment in money. The release of a debt may be held to extinguish an obligation in three different ways. 39. There are three different methods in which the release of a debt may be considered to extinguish an obligation. Number one, first method. As the obligation was created by the mutual consent of the parties, so it may be canceled and extinguished by the same mutual consent by which called it into existence. Now, as we have seen that by the general principles of the theory of signs, to create an obligation is denoted by plus 100 pounds over 100 pounds in parentheses. So as to cancel, extinguish, or annihilate, an obligation is denoted by plus 100 pounds over minus 100 pounds, again in parentheses. Now let us observe the effect of the negative sign on each of the parties to the obligation. The creditor's property becomes minus, and in parentheses, plus 100 pounds, but minus, and then in parentheses, plus 100 pounds equals minus 100 pounds. That is, the creditor has lost 100 pounds. The debtor's property becomes minus, and then in parentheses, negative 100 pounds. But negative, and in parentheses, minus 100 pounds equals plus 100 pounds. That is, the debtor has gained 100 pounds. Which shows that to cancel or release a debt is exactly equivalent to making a gift of money. Second method, as the creditor's right of action is simply a piece of merchandise, goods and chattels, or a commodity, it may be the subject of a donation or a gift, exactly like any other chattel or commodity. The creditor may present his right of action as a donation or gift to the debtor himself. Then the debtor will have the right to demand plus 100 pounds from himself, and also the duty to pay minus 100 pounds to himself. Then his property will be plus 100 pounds minus 100 pounds. These two quantities cancel and extinguish each other, like plus A and minus A on the same side of an equation. They vanish together. The right is not in abeyance. It is absolutely extinguished. The plus 100 pounds ceases to exist, as well as the negative 100 pounds, and thus the obligation is absolutely extinguished. The creditor has lost 100 pounds, and the debtor has gained 100 pounds. Thus, if a person makes another gift a gift of 100 pounds in actual money, and also releases him from a debt of 100 pounds, the donee has received a gift of 200 pounds. When Sir Joshua Reynolds died, he held a bond of Burke's for 2,000 pounds. By his will, he released Burke from his bond of 2,000 pounds. And besides that, he bequeathed him 2,000 in money. Consequently, Reynolds bequeathed 4,000 to Burke. Number 3, third method. There is still a third method by which it can be explained. When a debtor is presented with a right of action against himself, he fulfills two personae, or characters. He is creditor to himself, and he is also debtor to himself. In his persona of creditor, he presents his right of action to himself in his persona of debtor. In his persona of debtor, he pays the right of action to himself in his persona of creditor. Hence, the duty is fulfilled and discharged, just as much as if he had paid it to another individual. And thus the obligation is not in abeyance. It is canceled and extinguished. When plus 100 pounds cancels and extinguishes minus 100 pounds, and when it does not. Section 40. It must, however, be carefully observed that plus 100 pounds and minus 100 pounds, both in parentheses, in the same person do not always, and in all cases, cancel and extinguish each other in economics. A person's property may be represented by plus 100 pounds, negative 100 pounds, and therefore, for practical purposes, be equal to 0. Yet these two quantities will not cancel and extinguish each other in economics. It is only when the person has the right to demand from himself and the duty to pay to himself that both quantities vanish and the contract or obligation is extinguished. Suppose that a person has 100 pounds in a banker's notes and at the same time owes some other person 100 pounds. Then his property will be plus 100 pounds as well as minus 100 pounds, both in parentheses, and his property will be in substance minus and his property will be in substance equal to 0. But in this case, the in parentheses plus 100 pounds and the in parentheses minus or negative 100 pounds do not cancel and extinguish each other. The plus 100 pounds in parentheses is not extinguished as an economic quantity. Because the debtor may pay away the 100 pounds in notes in commerce and leave his debt unpaid. Suppose that two bankers each hold 100 pounds of each other's notes. Then the property of each banker is 100 pounds in parentheses, as well as minus 100 pounds in parentheses, and in substance, it equals to 0. The reason for this is obvious, because if a person has a right of action against A, that is no fulfillment of his duty to pay B. But in this case, the plus 100 pounds and the negative 100 pounds do not cancel and extinguish each other, because each banker may pay away the notes of the other in commerce, and therefore there are 200 pounds of economic quantities in existence. If, however, they exchange notes, each banker will then have the right to demand 100 pounds from himself and the duty to pay 100 pounds to himself. Then each of the obligations is simultaneously extinguished, because each banker has performed his duty of paying the other by releasing him from his debt. Thus, the 200-pound economic quantities vanish out of existence. Hence, it is only when the right and the duty emanate from the same person and are again revested in the same person from whom they emanated that plus 100 pounds and minus 100 pounds cancel each other and the obligation is extinguished.